Thank you, Yogesh, for your kind words. Very warm good evening to all. In the year 2019, there was Criminal Amendment Law Bill, which was passed with some changes in the basic criminal law. And mostly it was meant to bring it gender neutral in some of the offenses. But what is more important, there was a lot of changes in the some offenses which are very important. That is 354 IPC Indian Penal Code and also rape charges. There were a lot of amendments and a lot of things came into the purview of the rape charges. Previously, it was rape definition was very limited, but later on it was like any part of the body also if it touches, then also it was rape. We will discuss the rape charges in a one, I would say in a detail. But today we will be taking up 354 Indian Penal Code, which is very important. I would say before rape, we should go what is a 351 basic. Somebody is stalking you or somebody is showing you some video clip from his mobile without your consent. That is also an offense under Indian Penal Code, which many of us do not know. That we sometimes let it go, let him behave like this. But this is not done. He may be your relative, he may be your friend, he may be your teacher, he may be your senior. He can't do this. He can't show you any document or any video clip which is without your consent, which you feel it is offensive. If somebody shows me a nude picture, I will be uncomfortable. So this is an offense. So 354 IPC we will be reading today. What were the changes after the 2019 amendment? First, we'll go to the 354. 354 is assault or criminal force to women with intent to outrage her modesty. हम लोग पहले इसको बोलते हैं छेड़छाड़ का केस. It was so simple. 354 was bailable also, and there was no much punishment. Now it is maximum is 5 years. See the difference, and this all happened after the Nirbhaya matters in Delhi. 354 assault or criminal force to women with intent to outrage her modesty. Whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 5 years and shall also be liable to fine. Now this is simple. This was 354. This was not a punishment previously, but now it is 5 years. Now there are parts to it. The first part is 354A. It has been divided. This was after the Justice Verma committee gave the report after the Nirbhaya matter. Sexual harassment and punishment for sexual harassment. This 354A. A man committing any of the following acts: physical contact and advances involving unwelcome and explicit sexual overtures, or a demand or request for sexual favors. आपने कुछ बोल भी दिया, that is also an offense. Showing pornography, that is video clip बता दी against the will of a woman, or making sexually colored remarks. कुछ ऐसी बात मतलब कुछ कपड़े पे कुछ कमेंट कर दिया. This will be 354A. So you have to be very careful when you talk to women. Now next is, shall be guilty of the offense of sexual harassment. Now here, any man who commits the offense specified in clause 1 or clause 2 or clause 3, subsection 1, shall be punished with rigorous imprisonment for a term which may extend to 3 years, or with fine, or with both. Now third, any woman who commits any man who commits the offense specified in clause 4 of subsection 1 shall be punished with imprisonment either discretion for a term which may extend to 1 year, or with fine, or with both. Now next is 354B. Look at the definition and the description given in that. Assault or use of criminal force to women with intent to disrobe. कपड़े खींच रही है या कुछ खींचा ऐसे जानबूझ के. Any man who assaults or uses criminal force to any woman or abates such act with the intention of disrobing or compelling her to be naked shall be punished with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years. The punishment is different for different acts and shall also be liable to fine. Next is voyeurism. Any man who watches or captures the image of a woman engaging in a private act in circumstance. इसको voyeurism को the meaning is ताक झाक करना. But here because we have now mobile and many other things, the wording से उसका ऐसे captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by the perpetrator or by any other person. Suppose she is changing clothes in a bathroom और आपके हाथ में आपको कहीं से वो दिख रहा है और आपने जानबूझ के देखा तो वो गलत है. At the behest of perpetrator or disseminate such image shall be punished on first conviction with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 3 years, and shall also be liable to fine and be punished on a second or subsequent conviction with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years. मतलब maximum punishment यहाँ 7 years भी बताई, and shall also be liable to fine. Explanation भी है इसका. For the purpose of this section, private act includes an act of watching carried out in a place which in the circumstance would reasonably be expected to provide privacy. अगर वो अपने घर में कुछ कर रहा है, हमने देख लिया तो वो गलत है. If they are doing in garden, then it cannot be privacy. And where the victim's genitals, posterior or breasts are so exposed or covered only in underwear, or the victim is using a lavatory, or the victim is doing a sexual act that is not of a kind of ordinarily done in public. अब public में अगर कुछ garden में कर रहे हो तो it will not be voyeurism. Then it is in the public eye you are doing. The next is explanation 2, where the victim consent to the capture of images or any act, but not to their dissemination to third person. Ever such image or act is disseminated, such dissemination shall be considered an offense under this section. Now next we go to 354D, stalking, which is very common. It was previously also there, but now the definition is different way. I remember one case, one old man was caught. उन्होंने लिफ्ट में किसी यंग लड़की का मतलब फोटो ले लिया था. 354D लगा. सन वाज कॉलिंग मी कि मेरे फादर को पकड़ लिया. इट वाज वेरी एम्बेरेसिंग कि वो 60 years old, पता नहीं वो क्यों मतलब फोटो ले रही थी किसी लड़की का लिफ्ट में. Follows a woman or contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterest by such woman, or monitors the use of by women of the internet, email or any other form of electronic communication. आप उनका email भी नहीं देख सकते. Commits the offense of stalking. Provided, इसका मतलब पीछा ही करना, but somewhere you are just behind them. Provided that such conduct shall not amount to stalking if the man who pursued it proves that it was pursued for the purpose of preventing or detecting crime. अगर कोई लेडी क्राइम कर रही है तो आप उसको कर सकते हैं, ये एक्सेप्शंस है. And the man accused of the stalking has been entrusted with the responsibility of prevention and detection of crime by the state, or हो सकता है वो पुलिस ऑफिसर वो आपका पीछा कर रहा हो, then it can't be stalking. It was pursued under any law or to comply with any condition or requirement imposed by any person under any law, or in the particular circumstances such conduct was reasonable and justified. Whoever commits the offense of stalking shall be punished on first conviction with imprisonment or either discipline for a term which may extend to 3 years, and shall also be liable to fine and be punished on a second or subsequent conviction. जो बाद में वापस अगर आपने सेम ऑफेंस कंटिन्यू किया, कभी कुछ लोग वापस पीछा करना शुरू कर देते हैं, with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. Now what we see here, that 354 definition has become more wide now. You can't मतलब उसको exhaustive बना गया है, and for the purpose कि women can be protected. After Nirbhaya, the view is the of the society as well the parliamentary, the woman has to be they are subject to such kind of cruelty, or in a way they are stalking or voyeurism is going on, and because of the social media we have to take care, and because of it there was so many changes in this law. And this 2019 amendment is very important. There were other changes also. We will take one by one. This was the first one I want to take. Now Pragati will read something related to it only. Pragati, please unmute.
Yes, ma'am. Am I audible properly?
Yes, yes. Read why Bombay High Court granted anticipatory bail to constable accused of rape and other offences. Succinct report of the same. You can start from here.
Justice Sandeep K. Shinde granted anticipatory bail to a constable accused of rape and other offences as detailed below. Instant anticipatory bail application was filed in crime registered under Section 376, Clause 2, Subclause N, Section 354, Subclause 5, Section 417, Section 419, Section 427, Section 504, Section 504, Clause 2, Section 502 of the Indian Penal Code 1860, read with Section 66, Clause C of the Information Technology Act 2000. Applicant was attached to constabulary cadre of Maharashtra Police and was serving at the Traffic Department, Malabar Hill, Mumbai. Complainant developed a close friendship with the applicant after being deployed, and the same took form of a love affair. Later, the complainant alleged that the applicant has suppressed his marital status. Though the complainant alleged the applicant had informed her his wife was psychologically unwell and hence he desired to divorce his wife. Further, in the year 2018, the applicant borrowed money from the applicant from time to time, and when she demanded her money from him, he abused her. Applicant, on the false promise of marriage, persuaded the complainant to succumb to physical desires at various places and hotels. It was also alleged that the applicant had recorded her obscene videos and was threatening to upload the same on social media and disseminate the same to her relatives if she refused to maintain the relationship with him. Applicant damaged the complainant's cell phone to cause disappearance of the evidence also. After such incidents, complainant disclosed everything to applicant's wife. She also added that her proposed marriage broke down since the applicant sent some objectionable messages to her sister of her fiancé. So we'll come to the decision part. The bench stated that on taking into consideration the facts of the case, prima facie opined that since he has been suspended from service as and is available for investigation, a case granting interim pre-arrest protection was made. High Court directed the investigation officer to place the reports for further consideration on 19 July 2021. Lastly, the court added that the applicant shall join the investigation as and when called and shall not contact the complainant or influence prosecution witnesses. The name of the case is Madhav Krishna Vasabe versus State of Maharashtra.
This was the case. It was a love affair, and also what was more important here to notice that the court did grant the bail, but it has put condition. And here both were in love affair, so it was considered while granting the anticipatory bail, though he was a police constable. But the charges, if you can say, under IT Act also is applied, and rape charges also slapped against him. So this was very serious. But because of the love affair and also some other things, he was granted bail. And she was aware about the marital status also. There is one more piece. Pragati, can you read? If I ask you to do it?
Yes, ma'am, I can read.
Just a minute, because we have time. Just a minute. This is also a related one. Rape murder of rag picker merely because crime is heinous and brutal. It won't be just to get carried away, since any legal proof to substantiate charges. Detailed decision of Bombay. This is also again from Bombay. I was researching something. I had to apply for anticipated bail of one of the accused. Now here. You will be able to read it?
Yes, ma'am.
Start reading.
The division bench of Sadhna S. Jadhav and Prithviraj K. Chauhan while addressing an alleged rape and murder cases of two rag pickers, held that prosecution has utterly failed in connecting the dots and bringing home the guilt of the accused. Prosecution case. The instant case was sordid story of two poor, helpless victims who had not only been raped, but one of them had been brutally murdered. Victims were friends and rag pickers, which was their only source of livelihood. It was stated that survivor did not know why the accused previously. However, deceased X knew accused one. On the fateful day, survivor Y and the deceased X were both standing near a garden in front of railway station, and at that time both the accused came over and said that they would arrange for some job. Both survivor Y and deceased X decided to go along with the accused. Accused offered liquor and took both survivor Y and deceased X below the tunnel of a bridge and raped them. On resistance, both the accused assaulted them with a hacksaw blade and a knife. Deceased X and survivor Y sustained multiple injuries on the vital parts of their body. However, survivor Y escaped from the clutches of the accused and ran away from the spot. While running away, she fell down the bridge and sustained a head injury. She became unconscious. However, deceased X died on the spot due to multiple injuries. On the basis of information given by the survivor Y, an FIR came to be recorded. Crime came to be registered under the sections 302, section 376, clause 2, read with section 34 of the Indian Penal Code 1860. A reference under section 366, subclause 1 of the CRPC had already been made by the additional session judge for confirmation of the death sentence. Now coming to the analysis, law and decision. Whether the testimony of survivor Y, who herself is an injured witness, can be fully accepted as the truthful version of the entire episode of science corroboration, which is significant in the light of the fact that it has been held by catena of decisions that corroboration as a condition for judicial reliance on the testimony of a prosecutrix is not a matter of law, but a guidance of prudence under given circumstances. High Court stated that normally evidence of an injured eyewitness cannot be discarded in toto, particularly when the evidence is tested in the light of broad probabilities. It can be concluded that he or she was a natural eyewitness and had no reason to concoct a case against the accused. Court added that merely because she is an injured eyewitness, her evidence cannot be mechanically accepted, though her testimony holds more credence. Bench, while elaborating further, stated that looking to the report of the psychiatrist coupled with the fact that the survivor Y was under the influence of the liquor at the same time of the incident, it would not be safe to accept her testimony as a truthful version of the incident in respect of the alleged assault by the accused. It was expressed that in a criminal trial, a burden of proving the guilt of the accused beyond all reasonable doubts always rests upon the prosecution, and on its failure, it cannot fall back upon the evidence. Well settled principle of law. Corroboration is not a sine qua non for conviction in rape cases. Refusal to act on the testimony of a victim of sexual assault in the absence of corroboration as a rule is adding insult to injury. Additional sessions judge appear to have fallen into grave error in not recording the evidence of prosecution witness in Marathi, which is the language of the district court in the state of Maharashtra. In court's opinion, due to such a lapse on part of the additional session judge, a failure of justice has been occasioned and the proceedings stand vitiated. High Court, while taking into consideration of totality of circumstances in the case at hand, as well as failure on the part of the trial court in not promptly furnishing translated copies of English deposition to juvenile in conflict with law, may vitiate the trial, and it cannot be said to be a fair and impartial trial, especially when the capital punishment is sought to be inflicted upon the accused. Merely because the crime is heinous and brutal, it would not be just to get carried away sans any legal proof required to substantiate the charge of murder and rape. present matter at the most be a case of strong suspicious and no more. It was apparent that the murder was neither pre-planned nor premeditated, and evidence was neither clear, cogent, nor credible. Hence, there was absolutely no question of awarding death sentence to the accused. Rather, it was a case wherein the accused must be given a benefit of doubt, nay, it would be a travesty of justice. Trial was conducted in a casual manner without ascertaining whether the legal aid provided to the accused was competent and whether the trial was just and fair in capital punishment case. The quality and credibility of the evidence adduced is not even up to the mark. Since the prosecution miserably failed to bring home the guilt of the accused, there was no question of considering whether the case falls under the rarest of rarest category, wherein the question of award of capital punishment or otherwise would arise. High Court opened that the decision of the additional session judge was full of surmises and conjectures. The entire approach of the trial court in dealing with the evidence was patently illegal, and the conclusions arrived at it were wholly untenable. Therefore, bench acquitted the accused of the offences punishable under the section 376, clause 2, subclause G, section 302, and section 326 of the Penal Code 1860, in view of section 368, clause C of the Criminal Procedure Code.
Thank you, Pragati. Well read. Now, see, you saw these two cases, one where anticipatory bail was granted, and another case where they were charged, but because there was no much substantial evidence, they were acquitted. Charge was heinous and brutal, but there was no evidence. So, I would say under Indian law, it is very easy to file complaint, but to prove is the most difficult thing. So if you are for the complainant or victim, you have to have your tap on the law since beginning. If you are for the complaint, because always you will not be for accused. There is a possibility that you will be appearing for the victim, for the first informant, or for the complainant. All these three are one and the same. But then you should know that what will cause acquittal of the accused, what will give the bail rights to the accused. They can invoke 430, 430 and 439. Always remember, be careful whenever you are for the complainant. It is really very easy sometimes for to go get away with the charges because of the lack of the proper evidence. These were very important. Today's session is important in view of these two judgments, which gives the second judgment, which Pragati read. Actually, it has used very nice material and the words which you should be using in your regular bail applications and the criminal trials. I'll ask Vandana to put that judgment, which is of Justice Sadhna, and one more judge in the group. Now we'll be having little vocabulary, legal vocabulary words. The first word is empower. Empower is very regular word. Women empowering, women empowerment. You must have heard always. But here we will be using the word in the legal context. The Constitution of India empowers the court to do fair justice for people of India. Which see, court को भी कोई empower करता है. कौन करता है? Law empower करता है. Constitution of India empower करता है. Inequitable. Now inequitable is like injustice. This is really inequitable when neither you are returning the goods nor making payment. So आप whenever you are drafting, you can always say कि जब भी आप ड्राफ्ट कर रहे हो तो आप ये कर सकते हो कि बोल सकते हो कि आप he is becoming very inequitable accused. He is neither returning the goods nor making payment. Adherence. You have to adhere to time schedule. Adherence होता है, निष्ठा होता है to follow it properly. Nice practice, perfection. You have to adhere to the time schedule if you want to reach to your destination in life, or maybe to get success in life. Equity. Now this is also very common legal word, equity. The equity demand that you must pay back if you took the loan from the bank. The justice demands. Now next is Vested interest is a very regular word you will always file. You have had vested interest in the shop and therefore you never suggested that I buy the same. Because आपका कोई vested interest है इसलिए आपने मुझे कभी guide ही नहीं किया. You have had a vested interest in the shop. Therefore you never suggested that I buy the same. So vested interest is the very one good word which we use in the pleadings. Prospective. A prospect is always for future. Now the new law enacted. See, word use is enacted. New law made नहीं. New law enacted is always prospective. जब भी आप नया लॉ बनता है वो prospective. उसके बाद के सारे आने वाली क्राइम के लिए वो अप्लाई होगा या फिर anything prospective. Barring few exceptions where it is retrospective. In some cases it is retrospective, and who decide? This is Parliament decides. Legislature. Now, stare decisis. Now, this you all must be knowing. जो legal principle laid down किया है. The judgment passed by the High Court is not binding as it has not followed the stare decisis laid down by the Apex Court, that is Supreme Court of the country. Any judgment which is passed by the High Court, if it is in the absence of the legal principles enunciated by the Supreme Court or all the other High Courts, or in ignorance of the law, can never be a precedent, and it can never be a stare decisis. Next is meted out. Now meted out is like giving the cruel, but how it is giving? The cruelty meted out to the wife in the marriage was so worse that she had no option but to file a complaint or to file a divorce case. Unsound and erroneous. Unsound is, who is not having the proper knowledge or not in a proper frame of mind. Erroneous is mistaken, have some mistakes or the loopholes. The thought of asking a lady to go back to in-laws house after she had filed a complaint against all of them, it's actually an advice of unsound mind, totally erroneous. This is like sometime when the opposite lawyer says no, she can always come back, but if she has lost the complaint, then you will say it is a totally erroneous advice given to her. Squashing means dabana, या ऐसे जो से निचोड़ना है कुछ भी. The fat lady literally squashed us while pushing to sit in the bus. But the squash can be used in legally also. We can use this word. This is a new word. Prohibitions, which is very regular word, that is restriction. The prohibitions are many but rarely followed. बहुत सारे prohibition है. Like you can't jump the signal. You can't have the you can't drink alcohol outside. The provisions are many but rarely followed. Hence, law is broken at every step, and therefore this anarchy in the country. Anarchy मतलब अराजकता हो गई, lawless country, lawlessness. See, anarchy is also used and a prohibition is also used. So, I would say आपको legal vocabulary अगर develop करनी है, तो today's two decisions which Pragati read can be put in the group, and you can take out only 10 words. And make some sentences with the knowledge that what is the meaning of these words. And if you go on doing this 10 words each day, it will be like I would say 300 words a month. And these words will get repeated subconsciously in your mind. And when you are drafting, you will be using these words. You will be in fact using as a vocabulary. And when you use such good words, it is bound to help you before the court. Also, they impress the learned presiding judge, impress your opponents, impress the other lawyers, impress your client. So it's better as a lawyer, we should not use only simple words. See, we always say we should speak simple English. But when you are lawyers, you are in the noble profession, you are expected to use good words. See, the word anarchy, sought after, prohibitions, these are very important words. If you start using it, the cruelty meted out. Cruelty given is not the right word. The cruelty is done to her. Cruelty meted out to the wife. And this will be reflected in your drafting if you use it.